Hello, this is Matt on the Moon Lambo channel, and damn, it's good to be an XRP holder. Look at this headline from you today. Coinbase might delist Cardano and other tokens, CEO says. Now, I don't want that to happen, just to be clear. I hold Cardano. In fact, I have since 2017. So when I say it's good to be an XRP holder, it's not because bad stuff may be happening to developers building on top of other blockchains, other projects. No, not at all. Rather, it's good to be an XRP holder because XRP is the only damn cryptocurrency in the United States that's a large cap coin and has legal clarity. We don't have to worry about this crap. I mean, in theory, there could be overturning this or that, but frankly, by the time you're talking about getting to the Supreme Court, we're probably going to have legal clarity from Congress anyway, and it looks like Kim Jong-un, frankly, is in the process of giving up his war against crypto. Not that he's going to stop the lawsuit against Coinbase. He wants to save face, of course, but I think he understands that he suffered what is ultimately going to be a fatal blow when Judge Torres came to the conclusion XRP is not a security, because even if in a magical land, many, many years from now, that got overturned, he's not going to be in charge. He cares about what happens right now. You get a different administration in charge. You're going to have a different SEC chair, so on and so forth, and that on top of, like I said a second ago, what's happening with Congress. But it is fascinating to see how things have unfolded to this point, and I just wanted to let you know that Attorney John Deaton, he's still making some moves, man. In fact, as it pertains specifically to the Coinbase case, and that's what I wanted to share with you in this video. And it's interesting because he's making moves because people are signing up with him to be represented in the Coinbase case, which the judge would still have to allow. But there's a moment right now where, okay, he's making that move, but he's also intentionally not making a very different move, which I'm going to let him explain in his own words. But before going further, I do want to be clear. I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. Now, in terms of this first topic, I don't really feel the need to read this article from you today. It's fine, but just pointing out that as a result of what's happening with the SEC's lawsuit against Coinbase, he's just basically acknowledging, so they hold about, I think it's 240 assets on their platform. And there's they say 13 digital tokens here, including Cardano, and that are being called out by the SEC. And so there is a potential worst case scenario, where potentially Cardano and other coins would have to be delisted. But first of all, they don't think that's going to happen. And second of all, he points out that this isn't exactly something that would devastate their platform. But they really are fighting back against this, and they're using a lot of Ripple's actual defenses in fighting back against the SEC, including the major questions doctrine, including this idea that you can't really have an investment contract if there isn't a damn contract, you idiot stick. So I like that one. And I'm so glad to see Attorney Deaton jumping in everywhere he can. The drive that he has in this stuff, it's unparalleled. And I am just in awe of it. I really am. And I admire what he's doing here. Because who knows how the Ripple case would have turned out if not for Attorney Deaton jumping in, because we know for sure via the judge's ruling, Judge Torres' ruling ultimately, that everybody that signed up with Attorney Deaton and also everybody that filed for amicus, it absolutely played a crucial role in that case. And without that happening, it would be even harder for Coinbase to get a win. So we'll see what happens, but check this out. There's 4,200 Coinbase customers that want to be represented by Attorney Deaton. Now, 4,200. Check this out. So Attorney Deaton writes the following. So far, we have 4,200 customers who have joined to potentially participate as amicus curiae in SEC v. Coinbase. I've been asked by a few of those customers if I'll be filing an amicus brief in support of the motion below, filed yesterday by Coinbase. The deadline is August 11th. And I'll pause to note, and this is something I covered the other day, but Coinbase is filing a motion to have the SEC's lawsuit against them outright dismissed. Now, I went into reasons why it could be quite the uphill battle, not literally impossible. I don't want to rehash that in this video, but that's what's being discussed here. And so Attorney Deaton was asked by those who he seeks to represent, are you going to be filing an amicus brief in support of Coinbase's motion here right now? Excuse me, folks. And then Attorney Deaton continues. Because I'm now admitted to practice law in the Southern District of New York, I do not need to file a pro hoc vice motion before seeking leave to file a brief. But let me explain why I will not be filing a request to file an amicus brief in support of the Coinbase motion on August 11th. The Coinbase motion is focused on a narrow issue of law. Coinbase argues, and this is a quote that Attorney Deaton is sharing, the SEC has violated due process, abused its discretion, and abandoned its own earlier interpretations of the securities laws. But there is a more fundamental problem with its case, one the chair recognized 2 years ago, and that entitles Coinbase to judgment on the pleadings now. The subject matters fall outside the agency's delegated authority. The SEC may pursue this enforcement action only if relevant transactions in the digital assets and services identified in the complaint are investment contracts and therefore securities under the Securities Act of 1933 and the Securities Exchange Act of 1934, because as a matter of law, none of them are. The claims must be dismissed, end quote. So that's what Attorney Deaton shared, which Coinbase wrote. And it is true that Gary Gensler, back the year that he was, so 2021, as he was going through, I couldn't even say, I thought it was, I could actually, you know what, let me just put a little asterisk there, I could be off, but it was before he was SEC chair at some point. I was thinking it was maybe during the hearings leading up to him getting approved. I want to say that's right. Either way, the point is, before he was SEC chair, he noted that the SEC doesn't have the type of authority that he's now assuming in going after Coinbase. But this isn't the first time that we've seen Kim Jong-Gensler speak out of both sides of his mouth. Remember back in, whether it was 2018 or 2019, is back when he was at MIT, he outright stated that XRP itself did not have sufficient regulatory clarity as it pertains to guidance from the SEC. And I'm paraphrasing, but that's the message that he conveyed. And I remember upon that video getting unearthed by the Twitter sleuths, they became known thanks to Brad Garlinghouse. Brad Garlinghouse saw that, and if my memory's not failing me here, that was the instance where I think he just tweeted out in response to that video, he's like, I think he just said, "I love Twitter." I'm pretty sure that was it. I'd have to look it up, but it was something that it was either exact that or exactly that. He just saw it because it just destroys the case. It destroys the idea that there is somehow legal clarity for XRP specifically. You know, and like even if Judge Torres wasn't going to cite that specifically, and she didn't, and you wouldn't necessarily expect her to, she knows. She knows just how unjust all of this is, and judges are human. So I'm just saying. So that's why I was like, "Yeah, I love Twitter." I'm like, yup. Anyway, Attorney Deaton continues. In sum, the Coinbase argument is the digital assets identified in the complaint, as well as others that are traded and sold on Coinbase, are not, as a matter of law, investment contracts, and thus the SEC lacks jurisdiction to bring an action against Coinbase. Amicus curiae is literally translated from Latin and means friend of the court. Judge Torres allowed me to be amicus counsel because XRP holders, and this is a quote, XRP holders may view XRP differently from Ripple and thus may stress different arguments, and so they will provide the court with a meaningful perspective and will help ensure complete and plenary presentation of difficult issues so that the court may reach a proper decision, end quote. Okay, so there you go. That's the point of being amicus curiae, a friend of the court. And so it's really more of a timing thing. I'll let John Deaton speak for himself, but the reason that he's not jumping in at this particular moment, even though more and more people keep signing up with him, so taking action there, it has to do with the timing, not this idea, or concept that he wouldn't be able to put forth something very meaningful at a later date. But so anyway, here's what he says. Because the Coinbase motion is completely a matter of law and the judge's interpretation of the law, I don't believe I can offer the court the type of unique perspective on behalf of customers/token holders that Judge Torres referred to when granting amicus in the Ripple case. The law is the law whether token holders/customers agree or disagree with it, or whether they disagree with the SEC's interpretation/application of the law. Because this motion only involves issues of law, if I filed a request to be heard at this stage, it could appear to the judge that I am interjecting myself or others into the case for the wrong reasons, i.e., attention seeking. We all know by now that SEC lawyers will likely attempt to paint a negative picture to the court, especially considering their history with me. Trying to interject at this stage might risk minimizing any potential impact token holders / customers could have later in the case. Plus, let's be real here. I'm not going to out-research the Coinbase legal team. A brief by me on behalf of token holders / customers would likely be redundant and say, we agree with Coinbase. I'm not going to risk minimizing our role if we have one later in the case. And so again, folks, reminder here, we're talking about Coinbase's request from the judge to just throw out this whole case. So you can imagine the types of things that Attorney Deaton could argue if you're talking about all the broader assertions by the SEC. But when you're talking about this idea of, hey, here's the topic at hand, John Deaton saying, yeah, not my place. And so I get what he's saying here. And then he expands further and he says, ends up referencing Attorney Lewis Cohen. Attorney Lewis Cohen is the guy who wrote the Ineluctable Modality of Securities Law. And then the rest of the title, it's a long one. If you look at the smaller print, it's like why it's something to the effect of why digital assets are never securities or something to that effect. And that's the one where he looked at all of the case law dating back to when, I guess, 1946, went through literally every case by case, left no stone unturned, and found that there is no instance where there was an investment contract without an actual contract, and there's also never an instance where the underlying asset itself was the security. And so that's who's being referenced here. And so Deaton says, plus, there are other entities likely to file amicus briefs on behalf of industry players, securities law groups, academia, or others who should hire someone like Attorney Lewis Cohen, who's much better suited for this type of argument than me. What individual customers or token holders or John Deaton thinks the law is, or should be, would likely be considered last, if at all. Therefore, I will not be filing a motion in support of the Coinbase motion on August 11th. Please know, however, I reserve my right to change my mind if the SEC's brief triggers a reason or justification for retail holders / customers to speak up and request to be heard. If the SEC, in its opposition to the Coinbase motion, makes certain assertions on behalf of token holders / customers and doesn't limit its brief to issues or application of law, I may change my mind. The judge only gave 2 amicus updates, one date to file in support of Coinbase and one date to file in support of the SEC. In the Ripple XRP case, I didn't file the XRP holders amicus brief in support of Ripple's motion for summary judgment. I filed our brief in opposition to the SEC's motion for summary judgment. Anyways, I wanted to explain early why you won't see a filing by me next week. And so, folks, I wanted to highlight this because I don't know for sure what's going to happen. I'm kind of skeptical this thing's going to get thrown out, although I would absolutely love that. But I'm telling you, given that Gary Gensler, and I mentioned this in another video too, in case you missed this, I'll mention this too. Gary Gensler pointed out that he's going to have a strong focus moving forward going after AI, artificial intelligence. Yeah, I guess AI is now an unregistered security. So you can imagine the stuff that he's going to say. But why is he doing that? Why? Because, he was going full throttle against crypto. And that's what he wanted to do because, there is a such thing as an SEC budget. There's, you can say it's infinite money because it's the government. Okay, but still there's an annual budget for the SEC. And so in that sense, there are limited resources. And so you can't go full throttle on more than one thing. If you're really gonna really go, and as he was, that'd be crypto. So now for him to bring up, hey, here's another major thing we're looking into, like right there. As soon as I first saw that, I was like, oh yeah, this is Kim Jong Gensler acquiescing. He's never gonna say I surrender, right? And he's not, thrown in the towel in all the other lawsuits, but he understands that this has been a devastating blow. The judge finding XRP itself is not a security. So if you're talking about going down in flames with the Coinbase lawsuit too, bye-bye, Gary. Bye-bye. Bye-bye. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.